Hi, everyone, and welcome to the WSBA Crypto Roundup for August 2nd, 2024. I'm here with my amazing co-hosts, Quaranta and David Brill, as well as with our special guest for today, Nick Morgan. We're going to talk a little bit about Nick in a moment, but before we do, I just want to give the usual disclaimers, which is that nothing that we say is legal advice, investment advice, tax advice, accounting advice, really any kind of advice. These are our thoughts, and sometimes we're still formulating them as we speak. And nothing that we say is intended to represent the views of our clients, our employers, any other organization. It's just our own thoughts. So, with that, I'd like to just introduce again our special guest, Nick Morgan, who is the founder of the Investor Choice Advocates Network, ICANN. I guess, Nick, would you like to tell us a little bit about your background and your organization and what you're, what's keeping you awake at night these days?
All right. Well, thanks so much for having me on the program. I'm a big fan, so it's nice to be able to talk with the three of you. So I was a senior trial counsel at the SEC a long time ago in the enforcement division. And then for many years, I was defending people in SEC matters, most recently as a partner at Paul Hastings. And then this year, I decided to devote 100% of my time to ICANN, which is a 501c3 nonprofit. And in a nutshell, we push back against SEC overreach, and we provide pro bono legal services to people in SEC matters who can't afford counsel in potentially precedent-setting cases. So naturally, the topic of digital assets has come up a time or two in that mission.
So you haven't been too busy, Nick.
It's a target-rich environment. There's a lot going on, obviously, as you know.
Indeed.
Yeah.
By the way, David, if I could just weigh in with Josh and David. Sorry, Josh, real quickly. We're approaching the point where Josh is just going to say, like, we're not even giving life advice, like, to people who are listening.
We kind of are. Don't follow it, but we do have David's crystal ball and my magic 8-ball, which is very fallible. David's crystal ball has been pretty good. So I guess, where do we go from here? So much has happened this week. Shall we talk about the market and the newest reports that have come out?
I am happy to dive into that deep end of that swampy pool, Josh, if you and David and Nick will indulge me. And Nick, absolutely feel free to weigh in. David, it's been kind of a bloodbath across markets for the past couple of days. I had my hot cup of coffee waiting, and at 8:30, the data came in that for the jobs data, which basically showed a decrease, I believe, in expected expected new jobs, and I think the unemployment rate jumped to 4.3%, which in a normal non-bizarro world, David, would mean, oh, this is interesting. It should mean that the Fed is going to cut interest rates, and the market read that and said, oh my God, the Fed's behind schedule, and we're all going to die, and there's a recession coming, and the markets, bled out again today. David, everyone's risk off across the regular markets and crypto markets broadly. What are the tea leaves you're seeing? I've got some thoughts. Nick, I'd love your thoughts, and Josh as well. But David, where do we go from here?
Well, we've talked about it on the podcast before. We've all felt there's been underreporting of job losses and inflating of job hiring. And I think this just kind of bears it out. It's a very interesting time to sort of have a little bit of a reckoning, I think. I think we've all been expecting it for a while. So I think this might be one of the few job reports that might be somewhat accurate and actually reflective of what's going on. I do think, though, that the one thing that is very obvious now is that the Fed is a little late to the game. I think most of us had looked for cuts earlier. We said on the podcast we thought the first cuts would be in September. It feels like we're going to get maybe 50 basis points in September instead of 25 now. But I think the bottom line is we probably should have had 25 here. And, I think we're going to be playing a little bit of a catch-up. I think the last thing I would say is I still think there's double counting of temp jobs. And I still think the white-collar picture is a little more restrained than what's being shared publicly.
David, to that point, I think the minute we started talking about the market, it looks like we lost Nick. He either got bored with us already, or but hopefully Nick can come back. I just want to dive into that a little bit, David. And Josh, please chime in. I'd love your thoughts. We've made you an economics data nerd now, which I kind of feel bad about.
I'm trying to be.
One of the interesting things, David, I've been really deep diving into some of how the Fed's responded to the economic data. And there's a really good point. I forgot who mentioned it on, I think it was Bloomberg, that the Fed historically has always looked at prior data, which might have made sense. Everyone who's old enough to remember this, the late 70s and early 80s remembered high interest rates, high inflation, stagflation. It was really, really terrible. But in the 21st century, that's not the right approach. So to the point I think you made earlier, the Fed is already behind schedule on loosening credit in this country, which means a 50 basis point cut in rates might be in the cards for September. But that might also kick off a little bit of panic, David, because it will tell the market they are way behind and we're heading rapidly for a potential recession. Nick, I just wanted to mention that the minute we started talking about market conditions, I felt like you got bored and dumped us. I get it totally, but if you
I had some trades I needed to put on, so sorry, I'm back now.
But David, tell me where I'm wrong in that hypothesis. It's not the 70s when we talk about inflation. The Fed needs to be more forward-looking.
Well, look, globalization, the markets are more interrelated than they've ever been, and things are just moving a lot faster. So to rely on like historical data just doesn't seem consistent with the rate of how business moves. Look in our space, how things move so quickly, but also look at how, yield curves are trading, how some of the big tech stocks are trading. Nvidia's up $10 one day, down, several $100 billion the next day in market value, and, yields are moving 10, 20 basis points in a day. I just don't think the sort of looking at retrospective data is the best way to go about it.
David, how do you stay so calm when your book value goes down $1 billion given some of your holdings in Nvidia on a day-to-day basis?
Well, as all of you know, I'm super bullish on crypto, and so my macro views haven't changed. And all of us fortunate who have been in crypto for a while have seen the benefits of that. So, look, and frankly, I don't know if you look at what's going on this year. Should the market have been up 20%? Does it feel like that's where we should have been? I don't know that this isn't unexpected. It just always feels really painful when it's like a Friday in August and we're down 1,000 points.
Nick,
So
I
guys,
just want to. Okay, David. Go ahead, Josh. I'm sorry. Go ahead.
I was just going to say, for those who may be watching who haven't seen prior episodes where you guys have talked through this, I mean, what is your view of the relationship between the broader market and, as David noted, some of the bigger tech stocks and the crypto market, which sometimes has been seen as a hedge, right, including against inflation? I think you guys have expressed a number of views over the past weeks and months, but what are your thoughts there?
Well, I think the four of us go back long enough to remember when we talk about crypto as a negatively correlated to the markets, it's a great hedge. And now, major companies, like large enough companies like MicroStrategy and others are holding Bitcoin where there's a much tighter beta correlation for these. I think the volatility is narrowing. David, I'd love to hear your thoughts about that as well. But as the market goes, when it goes risk on or risk off so broadly, does crypto go? There's a lot more nuance to it. But David, I wonder if you or Nick agree.
Well, I mean, look, I think that it is somewhat correlated, but it has moved. And, we were correlated with Nvidia a little bit, and that's moved. I think the bottom line is now that we have the ETFs and, there's significant size in the market, that we're not seeing these rapid moves in succession with, the broader markets generally. I'd say the one exception is if you do have a very risk high event, like a black swan event or something very significant, I think will go down consistently with the broader markets. But otherwise, I think we're our own narrative and we're trading in our own ranges.
Yeah. I don't know, Josh, if you can see the comments in the back of the Rolls-Royce Phantom that you're in, but Jorge Tavares posted in the chat, big fan of you. I'm making the presumption, probably accurately, he's talking about Nick. So we should probably pull Nick into the conversation.
Well, I haven't followed the correlation between the digital asset market and the more broader market, but it seems to me like you all would follow this more than I. But isn't there a regulatory risk that may impact digital assets that doesn't impact the broader market. And I wonder if, how that plays out. But I haven't followed that correlation or lack thereof.
That's
Well, I
okay.
think,
David's got a crystal ball.
yeah, I think also, Nick, since we have clarity on Bitcoin and we mostly have clarity on Ethereum, so those two sort of, we know where they stand for the most part.
Yeah.
But yes, some of the other tokens, absolutely.
Yeah.
And I think
So,
that's a good
Nick,
segment.
I guess, are there any
Go ahead, Josh.
I was going to segue too, but it sounds like we were doing the same thing at the same time, David. So I was just going to say, Nick, are there any cases or any updates from the past, few weeks or months that really, you're excited about? Maybe some of the cases that you're working on, if you are able to speak about them.
Sure. Well, I mean, this week, it seems like every week something new happens. I think a trend that is interesting from my perspective as a longtime defense lawyer is seeing plaintiff side cases by digital asset issuers or others against the SEC. So, of course, the Song a Day case this week was important and serious, but at the same time pretty entertaining. The song was pretty good, actually. And of course, that's not the first. I think that's at least the third or fourth plaintiff side case against the SEC. And, we'll see if any of these make it past the pleading stage. But ICANN has supported a couple of these other suits, and I anticipate we'll probably weigh in on this one too. We have been pretty active in the amicus space, both ICANN as an amicus in many cases. But we have also represented people and organizations as counsel to the and one of those was in the Pulse Chain case, which I'm sure we'll talk about at some point. But we're excited about being involved in that case because it raises some very interesting issues.
Nick, I want to raise one. I wanted to raise one thing that Josh and David will appreciate. For some reason, like clockwork, every time we mention any cases brought by regulators, one of us has an alarm going off in the background, like a cop car or an ambulance. I don't know why. I suspect they're following Josh or not, but I just wanted to point out that alarm to you, Nick. But Josh, if I could, can I dive a little bit into some of the news with Nick and David and you on some of the SEC news? And Nick, I'd love your opinion, or at least please educate me. Some of the tokens that were previously part of the SEC's case against Binance were removed from the case. Can you explain for the audience, and David, Josh, chime in, why that would be the case and whether or not this changes the SEC's perspective on what is or isn't a security?
Well, my view is, my understanding is what has happened is the SEC has requested permission or leave from the court to amend its complaint. And one of the amendments, and I think there are more, but one of the amendment you're alluding to is that they would remove, they had listed 10 or a dozen tokens as exemplars to justify their request for relief for failure to register as a broker or as an exchange. So their request to the court, the SEC's request to the court, is to remove some, but not all of those sort of exemplar tokens that they had alleged are securities as a basis for their request for relief. As a litigator, I don't have any great insights into why they would do this, but as a litigator, it seems to me their position all along has been all the SEC, need to do is establish that one of those tokens is a security, and then we win on our registration claims. So let's simplify this case, and perhaps in response to some negative implications from some of the things the judge has said, why don't we just, if some of those tokens are controversial as to whether or not they are securities, let's just take that out of the case. We don't need 12, we need one. It'll simplify discovery, it'll remove contentious issues. So what I don't think it means is that the SEC is conceding anything about those tokens. In other words, that they don't need to say, we don't think those tokens are securities. They can just take them out of their complaint.
Yeah. An ignorant question on my part, David, Josh, Nick, could the court say no? Like, is there precedent for something like that?
Sure. So anytime you seek leave to amend the complaint, Usually that happens toward the beginning of a case. And normally it's, hey, we learned some new information and we need to add stuff in. It's pretty unusual to take stuff out. But this case is pretty far along. Courts normally are pretty liberal in granting permission to leave to amend the complaint, unless it's going to sort of delay the case or prejudice the other side. And here, I suspect the court will give the SEC leave to amend their complaint.
Yeah, one thing, if I can just jump in here, one of the things that struck me, and this goes to what Nick was just saying about some early maybe hints from the judge about which way she may go, is that we've seen in the past a number of cases, primarily, for example, in the Second Circuit, right, the Southern District, where we had Judge Torres in the Ripple case, and then Judge Rakoff in the SEC v. Quan case. We've had some other cases, obviously, that are still going on. But in that instance, Judge Rakoff really separated his views from those of Judge Torres in the Ripple case, whereas in the Binance case, Judge Jackson actually, even though it's a different, obviously, district, referenced the Ripple case, right? And also perhaps indicating that her line of reasoning was more aligned with Judge Torres's, and therefore perhaps in the SEC's view, although I can't speak for the SEC, maybe less friendly to their arguments. Also with statements such as, the dismissal of the claims against, in respect rather of USD, the Binance stablecoin, say, well, how can you have an expectation of profit if it's intended to have a stable value? These sorts of things, and also the references to secondary markets and things like that. Even though Judge Jackson came out after her decision on the motion to dismiss and said, "Hey, I wasn't trying to have any huge proclamations here. I was just looking at the facts before me." But maybe the SEC said, this isn't the case to be, or this isn't the opportunity that we're looking for to try and go against any particular issuers. But who knows? What do you guys think, David and Ron and Nick?
Well, I mean, look, first of all, on due process grounds, and like we said on our previous podcast, and then Commissioner Pierce sort of doubled down on that. Although I don't think she was listening to our podcast, but I hope she does, because we're in alignment. But look, you can't be making allegations against tokens and not have the issuers of those tokens as parties to the action. And so I will say that I'm glad to see that it was removed on those grounds, because that's just it's not consistent with the way that our laws are meant to be applied. And I think, I think Nick would probably agree from that perspective that if you're going to be, labeled as security, you should have the ability to defend yourself in those actions. So I think that's positive. I also agree that Judge Jackson's, prior rulings, I think the commission saw the writing on the wall and saw that, she likely was going to rule that those secondary trading in those tokens weren't securities. And then I think it would have put them further behind in their goal of having a different view. So I think this was, tactically appropriate by them. And, I think they're looking to live to fight another day. But I don't think time is on their side, after the Chevron decision, and just generally the way the market is looking. I don't think the opinions are lining up in their favor on this.
I've got a question for Nick, if I could. And Nick, I am the sole non-attorney on this broadcast, so please be patient. But, and I've raised this to Josh and David before, just trying to contextualize it. When David says something like I'm going to use the phrase anomaly to not go after the issuer of the token, but go after the platform that is listing the token. What is the legal and I'll call it operational implications or reason for that? What makes a regulator sit back and say, go after XYZ exchange for listing these tokens versus the issuer of the token? Is it the convenience of it? And I don't mean to be smug about it, or is it just harder to go after the issuers in a market like this? It's easier to go after the exchanges.
Yeah, I think it's a resource allocation issue. You're after the exchange. If you're successful in taking down the exchange, that addresses dozens or hundreds of tokens, as opposed to which the SEC also engages in the other option, which is the whack-a-mole option of going after each issuer. But I think David's point is a great one, that if you happen to be the company that is the issuer or creator of a token that is listed in an SEC complaint against an exchange, you're put in a pretty untenable position because you probably were operating under the assumption that your instrument was not a security. And here the SEC says that you are, but you're not a party. And very few token issuers, I think zero, would welcome the opportunity to be involved in the lawsuit. But if someone, because, who wants to be a party to an SEC lawsuit? So, what are you supposed to do with that information? You haven't been sued by the SEC yourself. You're not a party to the lawsuit where you're alleged to have issued a security. It's a very difficult and awkward position to be in. But to your question, Ron, it's just a more efficient approach to go after the exchange. It's resource efficient.
Yep, understood.
So, Nick, let's say I'm not going to pick a specific token because I don't think that's helpful. But let's say token A is named in the Binance suit. Do they even have the standing to intervene on their behalf? Like, would the judge let them come in and intervene, or are they not a named party and they don't have standing?
So anyone trying to intervene in an SEC lawsuit, in any subject matter, would face immediate opposition from the SEC. And there's actually a regulation on point. And the SEC makes the argument that, hey, we're a law enforcement agency. Allowing non-parties to intervene will slow us down in our mission. So there are very, very few instances historically of anyone being permitted to intervene in an SEC lawsuit. We'd actually like to change that because our position is that often there are issues that are extremely important to investors, community members that don't get addressed in the lawsuit. So we're stuck with acting as amicus, which is a much lower bar to be permitted to submit an amicus brief. Is a very easy thing to do, but one of the reasons it's easy is because you're not a party, and the judge is free to ignore the amicus brief, which sometimes happens. So intervention's almost unheard of.
Yeah. Nick, David, Josh, if I could just drop one more question in there. Again, this is a non-lawyer question, so I'm going right to you, Nick, and then David and Josh. This is what you get for being a guest on the show, and I'm hoping you come back in the future. Had a conversation with an investment banker buddy of mine, and we were talking crypto. He's not deeply involved, but I tried to describe and explain to him how the SEC in particular as a regulator looks at this. And I correct my phrase, Nick. I said, well, in many perspectives, they think the token is the embodiment of the investment contract. And I guess the feedback I got from him was, what the heck does that mean? So from, Josh and David and I and a lot of members in our legal working group have this conversation regularly. How should people in the market look at the SEC's perspective on what an investment contract is?
Chair Gensler just gave an interview to The Economist that came out, I think, yesterday. And he's used this phrase a lot. It's not his phrase, but he said, when the Congress created the 33 Act or the 34 Act, they painted with a broad brush. Mm-hmm. The embodiment concept has come up in this context, but if that gets knocked down, there will be another theory to apply as broad reading to the investment contract language as possible. So I think that, Chair Gensler has said this a number of times, that most tokens are securities because they are investment contracts, which is, and I know you've talked about this to death and, how he's been beaten to death, but I think the answer is they view the investment contract concept as very malleable, applicable to lots of different instruments, digital and otherwise. So that's one of the problems, of course, is the SEC understandably has been unwilling to acknowledge limits to that concept. Okay, so you paint with a broad brush, but at some point you come up against this thing is not a security. So why don't you let us know, where that limit is? And of course, the SEC doesn't do that.
Nick, thanks. I see the look on Josh's face. I'm probably in trouble for raising this question again. So I appreciate your answer, and I'll leave it there.
No, actually, I have a couple of questions for Nick. It's okay. Nick, since you're here and you're our resident litigator, So I guess, for example, in the instance in which a token is named, right, and a token, some entity that has released a token is named as well, say the allegations in the complaint are just wrong, right? And that token, the token parties, I'll call them, is they're not parties to the lawsuit and say they can't become them. How do you establish the accuracy or not of the allegations? Is that done through discovery? Would you do depositions? Like, how does that work in your mind if you were strategizing?
Yeah, you'd have to do it through discovery, and you'd have to do it on a token by token basis. And so the issuers of these tokens are going to get pulled in, if they haven't already been pulled into discovery. And I'm sure they don't welcome that. I mean, that comes with an expense and, a burden. But yeah, absolutely. And that, again, going back to the question of why the SEC may have requested permission to pull some of these tokens out of their complaint. If they've got 12, that's like 12 mini cases that have to be developed through discovery. That's a lot of work for everybody. If they narrow it down to 5, that makes discovery a lot narrower. And so, but yeah, the token issuers are going to get pulled into this. You've got to prove up each one of those. So it's going to be a lot of work. I want to say something about the way the SEC operates in terms of defining what things are securities and what aren't, because I think the industry has taken, understandably taken some comfort from some positive language that have come out of some of these district court opinions. The SEC doesn't view itself to be bound by district court opinions in any other district in the country. We're litigating a case right now in the Ninth Circuit, not a digital case, but it's a Howey case regarding an instrument that 30 years ago, the DC Circuit Court of Appeals, this is the SEC's home appellate court, said this instrument was not a security 30 years ago. And the SEC just continued to litigate in other circuits saying, yeah, but that's just that circuit. That's not the Ninth Circuit. So a win today in some district court, while people should be happy about that, we also should not think that the SEC views itself bound by that in other jurisdictions, even as to the same instrument. So this is a long road ahead of us.
Nick, to that point, doesn't the case law, does that begin to influence other district courts as more and more case law potentially errs on the side of, I don't want to say pro crypto, but at least not particularly sticking with some of the things that the SEC is advocating? Is that not something we should be looking forward to in the future?
Well, so I do think that obviously other litigants will bring helpful district court opinions to the attention of other district courts, and those will be persuasive, but not precedential, not binding on other district courts. So we've already seen some of that. You've alluded to the conversation between Judge Rakoff, for example, and the other judges, not direct conversation, but through their opinions. So that will continue, and certainly it's helpful. Mostly because the judge's analysis will be found, another judge will find it persuasive and helpful. Oh, that's how you looked at it. I'll help, that'll help me too. But it's not binding, right, as we've seen. So other district courts, even within the same district, are not bound by those rules.
Thanks, Nick. Josh, I did it again. I think there's a little lag. I cut you off. Go ahead.
Were you talking to me, Ron? Or
I was talking to you. I cut you off earlier.
I had a question for Nick as well. Okay. Oh, no worries. I was just going to ask something of Nick, which is, you referenced the Song a Day case that was just filed in, I believe, the Eastern District of Louisiana. It was definitely in Louisiana federal court. And we've seen a number of cases that have been filed in the Northern District of Texas, right, against the SEC in each case. And so a lot of times we've been talking about, and by the way, I should give a shout out to our friend Jason Gottlieb, who is one of the lawyers on the straight off of his win from Debtbox, right, on the Song a Day case, along with his co-counsels. But I guess one of the things about 3D chess or 4D Jenga, right, in terms of trying to perhaps prime an appeal to the Supreme Court. Do you see this? Like, how do you see this working or playing out?
So Louisiana is within the Fifth Circuit. Texas is within the Fifth Circuit. So I think that people who file there are hoping to get a friendly reception if they get up to the Fifth Circuit. And they might, and maybe the odds are better there than in other circuits. The normal path to the Supreme Court is a circuit split on the same issue. So even if you get a favorable decision out of the Fifth Circuit, you kind of need to, if you're going to tell the Supreme Court you ought to review this, you want to, another jurisdiction where the issue has been litigated to a different result. In the Song a Day case, one of the plaintiffs is a professor at a university in Louisiana. So I think there's a very clear, jurisdictional basis to file there. Some other cases, the jurisdictional basis looks a little fishy, but you can understand from a strategic standpoint why you would want to be in the Fifth Circuit. It's certainly more probable to get a favorable result there. I think the issues that we're presenting, we collectively as an industry, I think other jurisdictions will be receptive to them as well. I mean, look at what we've seen in the Second Circuit and in the DC Circuit. So I don't think that anyone should shy away from making these arguments in any circuit. I think, they're good arguments. We don't need to go searching for friendly jurisdictions. I mean, if it fits the case, then great. But I think we shouldn't shy away from other circuits.
So I've got a nice provocative question for you, Nick. Josh has been throwing you some softballs, so I'm gonna come in with some heat here.
Good.
So if we do have an administration change in this election, and we were to have a new SEC chairman, how do you see that affecting the litigation stance of the commission and active cases? Like, if you have a new commissioner, let's just say, for argument's sake, my crystal ball sort of sees Commissioner Pierce becoming chairwoman in January of next year. How does that work from the commission's, the inner working of the commission? And you have a new chairperson, they have a different view, and they have these ongoing litigations. How do policy changes get made in sort of this environment?
I don't think there will be much change, if any, to ongoing litigation. When I was at the SEC, I was there during a change in administration. I can tell you I saw zero change in my day-to-day life. A lot of this is not, a lot of these cases were started during the Clayton chairmanship. So a lot of this is not driven by who's in the White House. A lot of these cases are driven by the SEC's institutional inertia toward increasing its jurisdiction. And I think that inertia exists regardless of who is the chair. And I think, what you've got here is a vague standard in the Securities Act and the Exchange Act that has been, the SEC is not in the business, regardless of who the chair is, of defining limits to its jurisdiction. And I don't think that changes in a dramatic way, even with a new chair.
It's interesting. And talking about sort of opaque rule, parts of the 33 and 34 Act, I think this is a good time to talk about the pulse chain case and your involvement in that, and some of the novel issues that you're dealing with in that case, especially regarding software.
Yeah, so as the audience of your show will know, the pulse chain case was filed quite a long time ago, and it named an individual defendant, and it also named as named defendants 3 pieces of software, which is pretty novel. I don't want to say completely unprecedented, because of course we've seen other agencies do it, but it was a new thing for the SEC. And their theory was that these was a token, a protocol, and a system named as defendants. Their theory was that those should be treated like we treat corporations, who are corporations that are alter egos of the individual. that analysis, in our view, doesn't really fit. So ICANN represents a nonprofit foundation that was created to represent the users of the Pulse Chain community. So unrelated to the individual defendant, these are people who actually, for example, buy and sell NFTs using the Pulse Chain technology. And they are concerned that no one will be able to sort of speak up for the software defendants, and that the SEC will obtain a default judgment. They'll persuade the court. Of course, the SEC has to serve the defendants with the summons and complaint, which the SEC purports to have done through the individual defendant. And the merit of that, or the success of that attempted service, it remains to be seen. The judge hasn't weighed in on that yet. But our client is concerned that if the SEC gets a default judgment against the software defendants, the SEC has asked for unusual injunctive relief. The normal SEC injunctive relief in almost every SEC case prohibits the defendants from violating the federal securities laws in the future. The SEC has asked for that relief in this case, but it also has asked for an injunction against using these tools. So it puts the users of the Pulse Chain community users in a very tough position. There's an open question whether, if they continue to do what they're doing, in other words, otherwise lawful activity, would they be in contempt of an injunction that prohibits anyone with notice of the injunction from using the software. So it's a weird case in that it sues these pieces of software as defendants, and it's also unusual in the type of injunctive relief that the SEC is seeking. So we were happy to file an amicus brief on behalf of the Pulse Chain community, and we're going to, obviously keep weighing in. We already talked about the difficulty of intervening, so we're not going to try to intervene, but we'll continue to give the judge the views of the Pulse Chain community on this sort of novel attempt by the SEC.
Nick, out of curiosity, how would the court view, in this kind of novel, weird case, users who may not even, is it possible that users of the software may not be aware of the injunction and yet still be at risk?
Yeah. So, an injunction, Federal Rule Civil Procedure 65, applies to the defendants and their agents, and it's a long list of sort of affiliates of the defendants who are bound by it, who receive notice. So it would be difficult for the SEC just to sort of pick some person at random who say sold an NFT on the chain after the injunction was entered, to just run into court and hold that person in contempt. But I think the bigger issue is people will be chilled. They'll be intimidated, and there will be uncertainty about whether they're allowed to do, what they would otherwise be perfectly fine doing. If the requested injunction gets entered, it's not so much actual contempt proceedings, but the fear of and the uncertainty around the potential for contempt proceedings. I think that's the real issue.
Got it. Thank you, Nick.
So just a quick question on that, and this may be it is totally unrelated, but when you're talking about an injunction for users, for some reason it made a very old thing to come to mind, which is Napster. Like, is there some kind of underlying infringement that the SEC is saying is happening here, or is this just a potential harm to users? Like, what exactly? Why the injunction for users? And yeah, apologies for the blast from the past of Napster, but that's literally what popped into my mind.
Yeah, the injunction wouldn't specifically call out users. It wouldn't say users are prohibited from doing XYZ. The injunction would be as to the token and the protocol. The protocol is enjoined from engaging in this sort of these transactions. That's the way the sort of injunctive relief is phrased. So I'm not sure the SEC's thought it all the way out. There is no, like in the Napster case, there was an intellectual property infringement issue. That's not present here. It's the SEC's normal sort of paternalistic, we're saving investors from themselves viewpoint. So
when you think about your involvement in Pulse Chain, I think about Tornado Cash, and I think about the allegations brought, and I don't know if the developers are still in jail or not. I think they still are. Like, how do you think about that case and bringing an action against the developers of software? And there's so many great analogies about you can develop something, and just because you develop it doesn't mean you're culpable, because somebody could use it in a way that's illegal. Does that make you culpable?
right.
So curious to hear how you think about both the issue of going after the software or the developers, and then sort of software versus use, and sort of that vein of thought as well.
Yeah. And one of the best, I know Kayvon Sadeghi,
Yes.
he is generously acted as our co-counsel on the Pulse Chain case. And so any good and creative ideas were his, the rest are mine. But he has very articulately distinguished what's going on in Pulse Chain from the Tornado Cash case. But I'll say they do have some similarities in that, you're suing code essentially. One difference, which really probably shouldn't be a difference, is bad facts make bad law. And the Tornado Cash, the government is able to point to allegedly bad things that are happening as a result of this and use that to justify this sort of novel legal theory. In Pulse Chain, the SEC really doesn't have that ability. They can't say Pulse Chain is being used by bad people doing bad things. It's people buying and selling, silly NFT illustrations and stuff. So, but I do think that is the Tornado Cash strategy of sort of using the government using bad facts to avoid some of the due process requirements that are required. I think that is a useful tool. If I'm the government, it's useful to be able to say to a judge, if you don't do what I'm asking, bad things will happen. And that's when sort of due process can get sort of trimmed away. And it's important that not happen for the rest of us.
Yep. Nick, we know that Josh is the Rolls Royce is pulling over for her in a moment, so we might lose her briefly. I'm hoping, David, you and I, Nick and Josh, can digress for a brief moment. We kind of touched on it a bit earlier. And Nick, thank you so much for the context of the Pulse Chain case. I want to go back a little bit. I think we're all still digesting what happened in the conversations, David, in Nashville. And I would love Nick's opinion about some of it. It's not directly legally related in many regards, but it is certainly election related. We've had, a presidential nominee talk about a Bitcoin reserve, and we've kind of seen this this political pivot from the Democratic administration, the presumptive nominee, the current vice president. And I know you alluded to this a bit earlier, Nick. Do you think any of that administrative philosophic change advances or changes any of the dynamics that are happening in Washington?
Well, my specialty is certainly not politics,
Yeah.
but
Nor mine.
Yeah. So I think it appears that there is greater interest by politicians on both sides of the aisle to take the industry seriously and to take the industry's complaints about the SEC in particular seriously. So, that seems to be a healthy thing. David asked the question at the beginning, if there were a change in administration, if there were a change in the chair of the SEC, how much of an impact would that have? And I think it would have an impact sort of at the margins. I think there would be, if there were a more digital asset friendly person at the head of the SEC, the single biggest thing they could do that would be helpful would be to define limits to the SEC security. Tell us why Bitcoin is not a security. Tell us why ETH is not a security. Tell us what attributes a token should have that would put it beyond the jurisdiction of the SEC, and be specific, rather than just saying, go read Howie, which has been mantra for years.
Right.
So I think that would be the single biggest potential positive outcome if either party were to appoint a more digital asset friendly chair.
Nick, I'm going to raise this one other point, and Josh and David have heard it many, many times. I feel like your comments bring us back to the early days of sufficiently decentralized? And I'm still waiting for someone to kind of appropriately define that. But David, you and I had the chance to be in Nashville. I think Nick, you might have been there. Josh was certainly there as well. I'd still love to hear, David, your perspectives on some of what's coming out of that.
Yeah, I have one more question for Nick, and then I think we should jump right into it. So, Nick, if we were to have a change in administration, and there were, legislation proposed and being actively negotiated between the parties, like at what point does the legislative process get far enough along where the judges say, I don't want to decide on this right now. I feel like, Congress is far enough along in the process to, passing some sort of legislation that will govern this, that I kind of want to hit the pause button until we see that. Like as a litigator and as somebody who's worked for the commission, I know that's an imprecise science, but where do you think that point is?
That sounds like a variation of the major questions doctrine. In other words, a judge saying I should let Congress speak before I jump into this uncertain area with vague statutory language, which is certainly the situation we're in. And that argument has received a cold reception with every judge that's considered it. And maybe that's a reasonable response from a district court judge. And maybe we just have to wait to get up to a circuit court that's willing to sort of defer to Congress. But I think your question, David, is if we saw more progress on the legislative front, would we reach a sort of tipping point where a judge might be more receptive to either a major questions doctrine argument or a related argument? I think that's a possibility, but I think judges are sort of loath to rely on Congress doing anything. Maybe with good reason. So how do you tell when something is far enough along that a judge should sort of sit back and take a pause? Haven't seen judges be too receptive to that. Even judges that are appropriately skeptical of the SEC haven't gone so far as to show any love to the major questions doctrine arguments.
That's a really interesting perspective, and I think that's helpful. So, Ron, you were in Nashville. Like, what came out of Nashville that struck you the most, or was there anything that surprised you from what the candidates said, or was it really like as you thought it would be?
I mean, I want to say, and I think we're trying to get Josh back. I think the yacht may not have good Wi-Fi for her, so we'll figure it out. Josh, I don't know if you can hear us, but you're a bit frozen. Hopefully, we get you back soon. So, David, certainly there's a political fervor to some of the commentary when you see presidential candidate Trump. Some of the commentary was a little bit overboard for my taste, particularly the idea of maybe not overboard, but someone needs to explain to me the economic impact or significance of the Bitcoin reserve. I think the devil's always in the details. I think it goes against the ethos for a lot of the folks in the industry around decentralization. Which is always a bit of a concern. So to me, I want to see I tend to look at politics of what are the details of what you're talking about. Let's get beyond the flag waving and I'm going to be great for crypto. And I think the other side of that, David, is we still need to see what comes out of the vice president's campaign. I was surprised, David, Josh, or Nick, tell me if you agreed with this as well. With the news that the Harris campaign had reached out to Coinbase, for example, and I think, Ripple or some others that are in active litigation with regulators that work for this administration. So I'll be interested to see potentially what comes out of that.
What about you, Josh? You and I got to spend a few days out there. I had the good fortune of both hearing RFK and President Trump speak live, which I think regardless of what people's views are on the candidates, I think it's a great part of the process. Just sit there and listen to candidates' speeches. But what were your takeaways, Josh? I think the audio in the private jet's a little wonky over there.
I will raise one thing, David, and I'd love Nick and Josh to weigh in on. I mean, the four of us have been around long enough to remember, and we've had meetings with colleagues where we talked about crypto being an election issue, and we've heard several times, it's so insignificant, Ron, it's never going to tip the scales. And I'm not talking 3-4 years ago, David, I'm talking January, February of this year, maybe even a little later. And now this kind of election, these elections are happening at the margins where, Nick, we've talked about 1 or 2 percentage points in votes, small subsets of the populace shifting the election. Crypto is one of those subsets of the populace.
Yeah, I think that, I mean, I am not a political expert, but the way I understand it is this election comes down to a limited number of battleground states. And in those states, a limited number of voters who either can be motivated to show up, who wouldn't otherwise show up and vote, or who are undecided. And it does strike me that digital assets may play a role in that very small sort of tip of the spear of the election. It may, in other words, it may motivate some people to show up and vote who wouldn't otherwise, or there may be digital asset enthusiasts who are waiting to decide which party, which candidate to back. So it does seem like an issue that can make a difference in this election at the margin, as you say.
Yeah, I'm going to give up the attempts to bring Josh on board. I don't know if it's the jet or the yacht that she's headed to, David. I'm going to try one more time. And Nick, would I be out of turn putting forward David Brill's name for SEC chair? Is that me going overboard?
I support it 100%. Yes.
In the conversation.
I will say this. I've had the pleasure of strategizing with Nick on a number of matters, and it's been an absolute pleasure. And Nick has shown a lot of patience with some of my creative ideas on defending against inaction, and I've always appreciated that.
He's shown patience here, David, let alone in some of the work. We can see you, and I think we can hear you. Josh, can you hear us?
Yes, I absolutely can. I've been able to see you and hear you. It's the weirdest thing. So, I think Nashville is fantastic. I think we always talk about, I think we saw alignment and productivity that was really, such a large scale, so much crossover with politics. It's something really interesting and rather awe-inspiring. I was surprised, and I know we talked about this on the Twitter Spaces.
It's really hard to hear you, Josh, unless David or Nick tell me otherwise. We love our hosts, Nick, but sometimes we got to pull the plug. I'm sorry.
Well, they need a better yacht, I think.
We're working on it, Nick. David, Nick, as we approach the end, one of the things I wanted to raise as well, we've often joked about David's crystal ball. I'm going to pivot back to the markets a little bit. And I think it's kind of an important news article that I'd seen an hour earlier, not particularly legally related, but we've often talked about, David, the wirehouses coming to the market. And I think one of the things that's important, I don't know if you saw the news, Nick, but Morgan Stanley is now, which has one of the largest platforms for its brokerage firm in the market, is making the ETFs for Bitcoin and I think ETH available right now to its high net worth customers, 1.5 million in assets or over. David, is this kind of one of the plugs that's coming out of the dam that really moves it forward for other wirehouses for in a more retail level?
Well, we've always talked about a delay and how long it would take. And so, Nick, my view has been that there may be like a third of all the assets that could be invested in crypto that are invested in crypto. And so unlocking the wirehouses unlocks a lot of capital. And I think a fair amount of pent-up demand that wants to have exposure to crypto that haven't been able to. So, look, I mean, I had been hopeful that maybe we would see by the end of the summer, one or two of the wirehouses sort of unlock their customers. But I think I'm more leaning towards like a Q4 availability for the customers. And yeah, I think it's a big deal. I mean, look, I think ultimately people want to be able to invest their money the way that they see fit. And I think the success of the ETFs in terms of the functionality and the relation to price, they're running how they should be running. Yeah. And if they weren't Bitcoin or Ethereum ETFs, people wouldn't even be looking at sort of their function. They're just functioning like any other ETFs. So I think there's a lot of pent-up demand, and I think you'll see fairly quickly people allocating some percentage into crypto once the wirehouses start turning on the spigot.
So
one thing I hope doesn't happen, I agree with everything you just said, David. One thing I hope that doesn't happen is going back to the early days of ICOs, which there was a lot of fraud, there were a lot of problems. But one thing that there was that I think is a good thing is a lot of experimentation by lots of people who had no prior connection to the capital markets. And so I hope that with the growing acceptance of digital assets by big players, big institutions, I hope we don't lose that sort of sense of creativity and experimentation. We could do without the fraud, but this idea that, hey, I'm just a normal person, but because this instrument is computer code and accessible to lots of different kinds of people, I hope we don't lose that spirit of experimentation with the growing acceptance by the bigger institutions.
Yeah, and I think, Nick, to that point, I think David and I philosophically agree with you. The opportunities that, and again, we could do without the fraud, absolutely. All of us agree the importance of investor protections and adhering to the law, but the opportunity that it might, present for people to have access to the markets that, in ways they might not have had before in the long term, I think is a good thing. Nick, it's a privilege to have you here. This is my second meeting with you. I'm hoping you'll come back for others. I'm grateful to David for connecting us all. And I want to wrap up with a couple of things. I'm going back to David's crystal ball. I haven't looked at the market in a while. Nick, you can ask this of David as well. But David, what's the floor for Bitcoin coming up?
I think, barring something really material happening in the Middle East in the next sort of week, which obviously we all hope doesn't happen, I think we stay in this range. We've been in a range between 50, we hit 53 for a minute, but really like 58 and 70. So I think we're going to stay in this range in the 60s. I think Ethereum may go down a little bit, but I think we stay pretty range bound. I actually think sell-offs are positive. And they're sort of bigger in crypto because there's a lot of liquidations that happen quickly. And, I think there may even be liquidations in the stock market today. And for some reason why we've dropped so much so quickly. So I think, getting a little froth out of the market is healthy. And so, my view hasn't changed. But, look, if we were to go back down to 60 again, look where we've come in the last 6 months and where we are year to date. So I think it's just a matter of just keeping perspective and staying, a little calm about it.
David, fully agree. Josh, I think we've got you back. Let's talk about the Gulfstream updating the Wi-Fi next time we get together for a happy hour. But do you have any closing comments? And then we'll give Nick an opportunity to say hello, or say goodbye. And Josh?
Thank you.
I'm going to have to leave it there. Josh, I'm really, really sorry you were breaking up. Nick, thanks again for being a guest. For the folks in the audience, again, thank you for joining us. We'll have the recording available, and thank you for your great questions. Nick, if people want to follow you or learn more about you, where do they go? What do they do?
We can be reached at icanlaw.org. We're a 501c3, and we'll keep fighting the good fight.
Keep fighting the good fight, Nick. Thanks for joining us. David, old friend, good to see you as always. I think Josh is around someplace. We'll have to catch up with her, but it was great to have her as well. We'll leave it there. Thank you, everyone, for joining us, and we will see you all next week.